there are no annexures. It's a question of law.
But there's a question of maintainability also.
Yes, what is the maintainability, Mr. Ka?
Lord,
Let me hear the maintainability first.
Lord, kindly see the prayers in the writ petition. Lord, this is the mandamus that is being asked for, page 21. He says that writ of mandamus commanding upon respondent number 3, speaker, to permit and ensure petitioner being an elected member of the Legislative Assembly to participate in the proceedings, debates, discussion and deliberation of the House in accordance with the Constitution of India, etc. Now, Lord, this is relating to proceedings of the House. Article 212 is a direct bar of maintainability of the
For
right.
the member of assembly, you want an order from the court for hearing, opportunity of hearing.
I was appealing for the honorable speaker, my lord.
Sorry.
It seems, my lord, upon a perusal of the petition, my lord, it is a dispute inter se, my lord, a legislature party and a member. He says that the opposition chief whip is not giving my name every time, so therefore pass an interim order permitting me to speak. So an interim order, only he will speak in the House. It's a matter of procedure. It's a clear bar under Article 212, my lord.
Yes. Yes, Mr. There's the objection.
This is the
Just
preliminary
an
objection.
outline of the objection, my lord.
Correct, correct, correct.
Just an outline of the objection.
Yes.
No,
The petitioner before your lordship, he is an elected MLA from 164 Beleghata Assembly constituency.
address on the maintainability, but instead of facts.
And I am alive to the position in law regarding Article 122 read with Article 212 of the Constitution. And admittedly, that the parliamentary privilege not conceptualized under Article 105 read with Article 194. Who is the petitioner before your lordship? He is incidentally of the minority faction. Lord, admittedly, one matter has come up for consideration before your lordship's court, my lord, whereby the honorable speaker of the Legislative Assembly has, Lord, recognized a particular gentleman to be the leader of the opposition as well as the chief whip of the opposition. They are recognized. That came to be considered in a proceeding before your lordship's court. Your lordship was disinclined. The matter traveled to the division bench. I am told not the division bench has reserved verdict. Now, my lord, the majority faction is being represented. They are participating. My lord, I belong to, my lord, today the position is I belong to what is the minority faction of the opposing dispensation. Now, my lord, what is happening is, what prompted me to come to your lordship's court? Ordinarily, a decision as to who is to speak is ordinarily decided by the honorable speaker. My lord, there may be n number of occasions where during question hour, during, my lord, certain important mention matters, my lord, definitely, my lord, those are being permitted. But insofar as genuine debates over bills, my lord, the chief whip, despite my name being proposed from the minority faction, my lord, the underlying story is my name is never recommended or proposed as a speaker.
Yes.
As a speaker means not honorable speaker, but speaker in the debate. Now, as a consequence, as a consequence, let us understand this. Perhaps in the judicial history of our country, this is perhaps the first of such a matter which is being moved. Because, I have not been able to lay my hands on. Parliamentary privilege issues have travelled all the way to the Honorable Supreme Court, starting from, the special matter, in 1965, AIR 65, Supreme Court 745, the 7-judge bench, where, this issue came up for consideration as to what is the privilege of the Parliament or what is the privilege of the Legislative Assembly. But, this sort of an issue where an MLA is seeking the protection of the high prerogative writ jurisdiction under Article 226 of the Constitution of India, subject to correction, ordinarily no such matter has ever been moved. Even under but today the circumstances are extraordinary. An MLA who feels that he is being shut out, is before your lordship's court, not saying anything, but seeking a judicial review, not ordinarily 212 and 122 proceedings of the House not amenable to your lordship's jurisdiction. There is no doubt about it.
Correct.
But as we have learnt, judicial review, illegality, irrationality, procedural impropriety. Here, what is the procedural impropriety, that we are questioning? I am questioning. A faction which incidentally is a constituent of the assembly, very minority maybe, because the majority faction has decided to toe a particular line, and none of the bills today, whatever bills have been sent to the Honorable Governor, His Excellency the Honorable Governor, those bills, if not all of them, at least most of them, very normal debates did take place, where the majority faction, certain suggestions, certain submissions were made, but unfortunately, this minority faction, despite the names being proposed, the chief whip, who again is belonging to the majority faction, the chief whip, for whatsoever reason, doesn't send my name unless that name is rooted through him and the name figures in the list of speakers opposing a particular bill or a particular endeavor of the government. Otherwise what happens is, practically, this extraordinary situation today is there, that there is virtually no one to oppose. I am only seeking what? I am not saying that I am going to speak endlessly, ceaselessly. No. At least my name, whatever my name, if it is sent, at least it is rooted through at least it ends with the speaker, so that the Honorable Speaker allows me a brief time, good time, bad time, but some time to at least say something on a particular legislation. It's not a question of amenability to your lordship's high prerogative jurisdiction. Ordinarily, 212 I shall place before your lordship. No, it is not amenable. Proceedings are not amenable. That decision cannot be questioned.
What the court will do?
What I was humbly
Regulate the business of.
Milord, what I was humbly, Milord, there are three wings in our democracy. Legislature is definitely a wing. Legislative privilege, legislative practice inherits on the honorable speaker or the highest authority in the house to decide its procedure, and it cannot be regulated. There is no doubt, I cannot say that your lordship will lay down certain parameters. It cannot be, because those are exclusive to them. But if that exclusivity, which is inherent in their powers, if it is sought to be vitiated in ensuring that certain legislations see through and sail through without there being any effective opposition, at least if something is recorded, then it results in what is known as, if I may say so with greatest of respect, travesty of justice. It is one way of looking at the problem. One of the legislations, the Gundas Act, challenge was thrown. It is yet to be an act. It is still at the bill stage because it's relying with the honorable governor. The sum and substance.
Lying with the governor, it's lying, my lord. It has been reserved to be laid before Her Excellency the President of India.
What else?
State the facts correctly.
So what the order you expect from this court?
Now, these legislations that are being
Can this court can pass any direct the legislator sitting here in this jurisdiction?
Ordinarily no, but kindly also visualize, with pardons me, I know my reservations and limitations.
Also know this court's reservation.
There is no doubt, but kindly visualize that today the virtual face of the opposition faction, if it is shut out by inventing procedures so as to prevent actual speakers who can speak on a particular subject.
So why you have not made your grievance before the?
I have, those are, I have letters, but those letters are not officially stamped and sealed. It is not like that. I have made n number of endeavors, finding no other avail. I have come to your lordship's court. I know I have, my learned friends know that they have their best case.
See,
but it is very difficult to appear and argue.
Don't see there, don't hear that.
I am telling your lordship, I know my reservation, and I know that to argue a case which for the first time in the judicial history is being argued, perhaps because British parliamentary procedures that we have adopted, or even
But he had courage to raise this point in court because of Article 212. At least he had.
That's why telling you the first time he is making that.
Let us look at it. Whether in exercise of powers under Article 226, whether your lordship will, at least decide this question, maybe against me, but decide this question. I cannot today say that from Monday or whenever the house begins, because the house is from 17. So 17, I will be permitted to be a part of all procedures. I cannot pay for the interim order. I know, the reservations and shortcomings, but kindly I will request your lordship, appearing for the petitioner. But the sum and substance of my case is there is virtually no opposition to oppose in the house. Maybe the opposition, either if the government of the day feels that there should not be any opposition, that is one thing. If the government of the day feels that there has to be in democracy some sort of an opposition not for the purpose of mere opposition, practical opposition, previous days,
My learned friend is not addressing the House, my lord. He's before the Honorable Court of Law, my lord, in Article 226.
No, no, he knows his restriction. That's why he is arguing what.
Thinks that, my lord, he's
Yes.
in the House, my lord.
Let me hear.
Monsoon
That's
session.
all.
Well, I am trying to voice the concerns of my electorate vis-a-vis the people of the state who do not have the voice and
That's what I'm
courage.
telling you. Show me how this court and what.
Well, your lordship will kindly decide the question. That is my only submission for the present. Your lordship will, if it commends to your lordship to call for affidavits, my lord, let the question be decided against me, maybe, but let it be decided. That is my prayer.
Okay. Yes.
Keep the maintainability point open and give us directions for filing affidavits, but not on the face of it. This is not a writ petition which is maintainable. Kindly, my lord, have a look at Article 212.
I would have prayed for a dismissal outright, my lord, but I'm not praying for that because my learned friend, my lord, will go to the Honorable Division Bench saying that there was no opportunity granted to file affidavit. But if my learned friend says that no, he has no objection, if the matter is decided without affidavit,
I mean, only one thing. An alternative thing can also be worked out if it. I am not saying, I am requesting my learned friend and my learned senior friend, my lord, if I can, if without anything, if I make these requests to the chief whip or the honorable chief, they shall, my lord, judiciously consider it and, my lord, at least allow me to say.
Lord, if he applies his mind, he will understand that there are 294 legislatures. The speaker has to give everybody a turn. Lord, on the 23rd of June and 24th of June, he spoke first, Lord, on the governor's speech and then, Lord, on the budget. And Lord, the leader of opposition was also allowed on these 2 days only. So, Lord, it's not that, Lord, he is being singled out. If he wants me to address on facts, Lord, I can address on facts. The parliamentary practice lays down, Lord, precisely as to how a person can speak in the legislation. Lord, I'm not here to educate my learned friend's client. If he goes through the parliamentary practices, he goes through the rules, Lord, which has been framed, he will understand, Lord, what is how it is to be done. Number one. Number two, Lord, if your lordship looks at Article 212, my lord will find the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. Now, Lord, this is a proceedings of the House. How the speaker, Lord, how can the court, Lord, regulate who's going to speak on which day, on what topic? Lord, this is absolutely a proceedings of the House. Therefore, Lord, there's no question, there's no chance of, Lord, coming to writ court, Lord, rushing to the writ court. And your lordships will see that, Lord, it clearly says that the validity cannot be challenged. So, Lord, if Article 212 is a bar, there is no ground, Lord, to come to court and say, and Lord, there are judgments of the Supreme Court, Lord. If your lordship, Lord, entertains, Lord, affidavit, Lord, I can file an affidavit keeping the point of maintainability open. The point is very well settled. That, Lord, in so far as Article 212 is concerned, the proceedings of the House cannot be challenged. And this is a clear proceedings of the House as to who will speak. The court, Lord, has no jurisdiction in Article 226 to direct that who's going to speak next, whether, Lord, every that is, Lord, that comes up in the legislature, Lord, whether the petitioner will have to be permitted to speak. Lord, these are issues which is beyond bounds, Lord, under Article 226.
Yes.
So, Lord, my first submission is based on Article 212, simple Article 212, kindly do not entertain the writ petition.
Yes.
I may just indicate, my lord, it's more like, my lord, I have item number 90 in the daily cause list, but my lord, I file a writ petition saying that no, it might be item number 90, but I will have a right of audience in all the matters from item number 1 to 89. But the Honorable Speaker is the custodian of the House. However, it is to be regulated, the right, my lord, as to, my lord, the order of speech. It is a procedure, my lord. to be regulated by the Honorable Speaker. So first of all, my lord, there are averments that he has never been allowed to speak, which is a misstatement on the face of record. I can produce the records to demonstrate, my lord, that he has, my lord, in fact, addressed the House on more than one occasion, my lord. My lord, this is clearly hit by Article 212, my lord, as rightly pointed out by my esteemed senior friend. And that about, my lord, he cannot say that I have a right which is unfettered. He said that he was on the Wednesbury principle, illegality, irrationality, procedural impropriety, my lord. We both have learned that, my lord, while from the same chamber, my lord. But procedural impropriety,
The three of us, we have grown up together.
procedural
We are otherwise very
impropriety,
attached to each other, so he has the right to say these things.
procedural impropriety,
No, but he says something wrong. You have a right to correct him.
No, wow.
procedural impropriety, my lord. It's a Friday evening. I will not detain Mr. Bhattacharya for long, my lord. Procedural,
Especially.
especially it's a Friday evening.
এটা বন্ধ আছে কি? দেবো?
No, no, I will keep it in mind because of fixing the dates. So then.
I may not hold him back, my lord, on Friday evenings, my lord. So procedural
Difficulty is, everyone eats everything. সব বেটাকে ছেড়ে আমাকে ধর।
কিছু বলিনি তো। আমি তো কিছু বলিনি।
করে আমাকে
মানে
পেছনের যে
এই,
কিছু লোক
কি হচ্ছে? Procedural impropriety is qualified by the bar contained in Article 212 of the Constitution of India.
Impropriety, even irregularity. Bar.
So it is only illegality. So irregularity and procedural impropriety, it is not there. But there is no case of procedural impropriety which has been made out.
Yes.
No case. My lord, even if we refer to, my lord, if we refer to, my lord, the parliamentary procedure and practice, my lord, as contained in, my lord, Erskine May, I'll just produce it, my lord. Now we do.
Obviously.
না আমার একটাই বই অনেক কষ্টে এটা খুঁজে পেয়েছি এখানে পাচ্ছি না
One thing is surprising. The opposition and the honorable speaker, they are speaking in the
No,
same
I am on a question of maintainability.
same
not
voice. The opposition.
Because we are.
See,
I cannot change the law, the legal.
See, you will appear for your client. What your client is giving the instruction, other than the law, you will speak on that. That law you have to interpret.
Sorry, he doesn't not believe in the discipline of the opposition party. He is part of the same political party, but he doesn't believe in the discipline. That is the main problem, and for which he has suffered.
I'm very surprised that this submission is being raised.
Giving some hints to you.
Giving enough fodder for me. Yes. Hints.
He has himself suffered for
Hints
that.
as well as fodder.
So that if we even refer to, my lord, the rules of debate as contained in Erskine May, where it says, no, it's a very rare book, I got it after a lot of search. Because the Lord Speaker has no powers to rule on matters of procedure, the leader of the House normally advises the House on procedure and order and has the responsibility of drawing attention to violations or abuse. Leader also expresses the sense of the House on formal occasions such as motions or things or congratulation. However, like the Lord Speaker, the leader is endowed with no formal authority. In the leader's absence, the deputy leader endowed with no formal authority. In the leader's absence, the deputy leader, government chief whip, or other government whips assume the leader's duties. The opposition front benches and the convener of the crossbench peers also have a responsibility to draw attention to order. So this is completely within the prerogative of the opposition whip because he belongs to the party in opposition and will not kindly appreciates or opposition whip. But he does not come also within the definition or purview of Article 12 of the Constitution of India. So, if an opposition whip, my lord, from amongst his parties, he supplies a list. So, how can that be attributed to the speaker? This is, my lord, one. Secondly, again, my lord, I'll fall back on that, my lord, that it is nothing but a procedure. It is regulating as to who will speak. That is absolutely coming within the but pale of procedure. So there is a clear bar under Article 212.
Yes.
But,
Lordship will kindly decide the question.
yes, by dismissing the writ
No,
petition.
affidavits will not keeping the question.
No, it's a
open.
question of
But
it's not
keeping the
maintainable
question
in the
open.
face of it.
what required?
Milord, it is required, Milord, what?
Mr. Bhattacharya may not add to the burden of the honorable court. There are
Milord,
lots of other
Let
matters.
the matter be. I am not saying the matter should come up.
And we read a statistic. We read a stat. No, he will show that the honorable court has admitted by petition. I know what will happen. I know why this.
But he also knows what am I to say. He is going to control what am I to say.
We have made our submissions, Your Lordship kindly decide.
The petitioner has filed the present application praying for the following relief.
Milord, only thing is, if your Lordship is disinclined, that is, Milord, I am taking it. Milord, in that event, Milord, that should not be construed as a complete fetter, Milord, for me to approach.
Maintainable. So, not
I am deciding only writ petition with regard to your standing before your assembly. You do you whatever. This court
Kindly clarify.
it's a question of maintainability that my lord is deciding.
Now it is a question of entertainability also.
the petitioner is a sitting legislative member of the Legislative Assembly of West Bengal Legislative Assembly. Full stop. The grievance of the petitioner is presently Legislative Assembly and is the elected member of the Tribunal Congress. The main grievance of the petitioner in the present writ application that the petitioner is not being allowing by the Speaker of the Assembly to raise any query at the time of debate. It further submit that several bills have been passed. Like West Bengal Public Safety and Control of Anti-Social Activities Bill 2026, Police Budget, Finance Bill, Municipal Affairs Budget. But the petitioner has not been given the opportunity to raise any objection or to speak on the bill introduced in the Legislative Assembly. He prays for a direction upon the Speaker of the West Bengal Legislative Assembly to permit and ensure the petitioner, being the elected member of the Legislative Assembly, to get an opportunity to object or speak about the points raised in the Legislative Assembly. The learned counsel for the respondents raised the point of maintainability and submits that the writ petition filed by the petitioner is not maintainable. They referred to Article 212 of the Constitution of India and submits that the validity of the proceeding in the legislature of the state shall not be called in question on the ground of any alleged irregularity or procedure. Learned counsel for the respondents further submits that the petitioner has been given an opportunity to speak more twice, but the petitioner has suppressed the said fact and made out a case that the petitioner has not been given any chance to speak. Consider the submission made by the counsel for the respective parties, produce the prayer made by the petitioner. Article 212 of the Constitution of India reads as follows. The main grievance of the petitioner in the present writ application that the petitioner is very insubstantial. Petitioner is the elected members of is one of the sitting member of the Legislative Assembly. But but he has not been given an opportunity to speak in the assembly. He has pointed out the that the four bills have been passed by the assembly, but in none of the bills the petitioner have been allowed to speak. This court finds that if the petitioner is agreed without giving an opportunity to speak, the petitioner has to resolve the issue with regard in the assembly itself. The procedure which has been adopted by the speaker or the whip of the legislative assembly, this court cannot pass any order directing either to speaker or to the whip of the assembly to give an opportunity of hearing to the petitioner. Article 202 of the Constitution of India clear are this court to entertain any such allegation in the writ application. Considering the above, this court finds that the writ application filed by the petitioner is not maintainable. Accordingly, WPA number 361 of 2026 is dismissed. However, the petitioner, whatever the grievance is the petitioner is having, the petitioner can raise all the grievances before the legislative assembly.
And we have tried.
Since it is Mr. Bhattacharya, I did not make any formal prayer, my lord, for payment of costs.
No,
There was
no,
statistics.
no, I was thinking that he will ask for the stay of the order.